Hello guys, so welcome to another episode of my lecture, and on today's episode we'll be talking about Res Gastae doctrine. That's the doctrine of Res Gastae. Now, in my previous series of lectures we went through section 1, section 2, section 3. Now we've got into section 4 of the Evidence Act, and it's very pertinent to know that there has been this debate as to whether or not section 4 is actually the common law doctrine of Res Gastae. Do you understand? So now we have to look at the common law doctrine of Res Gastae first before we get to what exactly section 4 actually talks about. Do you understand? So we are going to start with the common law doctrine, and please note that evidence is extremely easy. Res Gastae doctrine, section 5, section 6, section 7, which is going to be our next subsequent set of classes. It is very simple and interesting. So I want you to open your mind while we learn this. Now let's go to my notes. Now today's class will be talking about the scope of Res Gastae doctrine. And now, in any trial, be it civil or criminal, evidence has to be led of relevant facts to establish the case of the parties. I'm very sure that we do understand what that means. You cannot establish a case in court without adducing evidence to support your case. If you don't adduce evidence, your case will fall like a pack of cards. Now, according to section 1 of the Evidence Act, it says evidence may be given in any suits or proceedings of the existence or non-existence of every fact in issue, and of such other facts as are hereafter declared to be relevant, and of no others. Now, if you take a good look at this section, it has two classes of facts. The number 1 class is fact in issue, while number 2 is fact relevant to the fact in issue. Do you understand? So now, when we are talking about facts, we are talking about fact in issue. Whether or not Bola killed Tolu, for example, the issue is whether or not Bola had the intention to cause grievous bodily harm on Tolu. That's our issue. However, there are certain facts that are not in issue but might be relevant to the fact in issue. Do you understand? And while you adduce those facts relevant to the fact in issue, it helps us to get to the conclusion of the fact in issue. What if Bola, the alleged murderer, at the time of the commission of the offense was blind? What if Bola, the alleged murderer, at the time of the commission of the offense had dementia? Dementia is not a fact in issue. Whether or not Bola had it is not a fact in issue, but at that point it can be relevant to the fact in issue, that is whether or not Bola killed Tolu. Do you understand? So in the law of evidence, you have two set of facts that are admissible according to section 1. Number 1, fact in issue. Any fact that supports the issue will be regarded as important facts, relevant facts, which should be adduced as evidence in court. Another kind of fact is fact relevant to the fact in issue. So standing on their own, the fact that Bola had dementia or the fact that Bola is blind is not relevant, to the case. But because we are talking about this particular murder case, it then may become relevant. Do you understand? So for example, if it were to be like a criminal defamation case where somebody defamed another person and you are saying that the person is blind, I don't think that that's going to be a relevant fact in issue. Why? Because what we are talking about is that he must have made utterances. If the fact that he is dumb is what you are saying, then that can be relevant to the fact in issue. That means that he cannot speak. Then if he couldn't have spoken, then how then could he have defamed? Do you understand that? You get that when you are talking about facts in issue, certain facts standing on their own might not be relevant to the issue. When we now look at the issue that we are talking about in question, those facts standing on their own, which wouldn't have been relevant, might then become relevant. Those are the things that we call fact relevant to the fact in issue. So let me continue with my notes. Falling within the second class of facts of which evidence may be led are those commonly referred to as res gestae. Now, the term res gestae, interpreted by John Burke to mean the things done, has common law origin. They refer to a collection of those facts relevant to the fact in issue because they throw light on it as a result of their proximity to it in point of time, place, and circumstances. This set of facts that so closely accompany the fact in issue, so much so that they could be set to form part of the same transaction. They also help to explain the fact in issue. Now, the question whether or not the doctrine of res gestae is directly applicable under the Nigerian law has generated some controversies for some time. This is because Section 4 of the Evidence Act would appear to embrace the doctrine to a particular extent. Now, what does Section 4 say? It says facts which, though not in issue, are so connected with a fact in issue so as to form part of the same transaction are relevant whether they occur at the same time and place or at different time and different place. Now, this is quite complicated, but I want us to take it step by step. I don't want us to rush through the process. Now, for the first time, we heard what fact in issue was. We understand that there's something called relevant fact, that is facts relevant to the fact in issue. Standing on their own, they do not make sense, but when you read it in line with that is in fact in issue, that is the fact in issue, you would see that, oh, this then makes sense. Do you understand? So to give you a typical example, now there's a particular trial where somebody in the night around 11 p.m. said that he saw two people fighting downstairs, and this is a 3-story building, very high. Two people fighting downstairs around 11 p.m. There were barely street lights on, but he said he could see them. He does not know them personally, but he could see them. One person killed the other, and the other was taken to court for killing. Now, when they got to court, the person who allegedly saw Mr. A killed Mr. B came to testify. Now, they led, the evidence, that's the prosecution. They did the examination in chief. Now it was time for cross-examination, and this person, a woman, now she has been wearing hijab all her life. Do you understand? And right from when she was little to when she grew up and all that. So the first series of questions that they were asking, that's the defense was asking this particular eyewitness. Number one, how long have you been wearing the hijab? That question, at that point, everybody was like, what is going on? She said she saw Mr. A kill Mr. B. You are asking her how long she has been wearing the hijab. My friend, are you alright? Do you understand? Like, it has no connection to what we are talking about here. What we are talking about here is whether or not Mr. A killed Mr. B. Eyewitnesses have come to testify that he saw or she saw Mr. A kill Mr. B, and you are coming here to ask questions as to how long she has been wearing hijab. Objection, my lord. This is not relevant. Then he said, no, my lord, just give me a minute. I'm going to show you the relevance of my question. Then he said, okay, answer. Then he asked again, how long have you been wearing hijab? Then she said, oh, since when she was a little girl. And she said, oh, so which means that you do not go out except you wear hijab? She said, yes. When you are in your house, do you wear hijab? She said no, she doesn't, because Islam doesn't say that she should wear hijab in her house, at least not all the time. But when she's going out, she has to cover her hair. And note that she wears hijab with also the niqab. Do you understand? And he was like, oh, okay, that's great. Then he then said, so which means for the past 20-something years of your life, you have been wearing hijab. The other lawyer was already angry. Objection, my lord. What is hijab doing here? We are not talking about hijab. We are talking about whether or not she saw Mr. A kill Mr. B. Even me at some point, I was like, okay, what's going on? Lawyer, is everything all right? And then he said, my lord, just give me time. My lord was saying, my brother, your time done, they go. Do fast, hurry up. Then he was like, okay. Now, do you know the lack of sunlight, which ultimately gives vitamin D, would deprive you of such vitamin? And the other lawyer objected and said, my lord, he is not a medical doctor, he cannot testify as to that. Then my lord said, yes, objection sustained. Then he now asked her a direct question. Do you have diabetes? Now, diabetics most time is caused by lack of vitamin D in the body, so which means that if you have a lot of sunlight, that does not mean that you should go and fry your head in the sun. That's what I'm saying. Sunlight, the vitamin D sunlight is the one that you have in the morning. That's very mild sunlight. When you have it, close to your body, then you are able to gather more vitamin D. And then the woman testified that yes, she had diabetics. Now you can see diabetics affect the eyesight, and if he is able to show that she has diabetics which could have affected her eyesight, then how is it possible that she can be so sure that the person that she saw was the person who allegedly committed the murder, which is the lawyer's client? You can see how from nowhere we have got it to somewhere. From fact which is not originally relevant, the fact that she has diabetes wasn't relevant. I mean, that's a medical condition, was her business. But he can pin it to her eyesight, which then becomes relevant to the fact in issue, whether or not he actually saw the murder. Do you understand what I'm saying? So we have fact in issue, which, clearly whether or not Mr. A killed Mr. B, and then we have fact relevant to the fact in issue. Do you understand? And this is one of the places where res gastae doctrine falls under. In my next lecture, I will start the common law doctrine of res gastae, where we peruse through what exactly is res gastae. There are 3 elements that must be satisfied before we have the res gastae doctrine, and I will talk about them in my next subsequent set of videos. I will see you in my next lecture.